Lewis County. This matter is before the court on Mr. Hupy's motion requesting that the court strike the answer filed by Lewis County and impose CR 11 sanctions. Mr. Thomas is present, correct?
Yes.
Yes, on behalf of Mr. Hupy and Mr. Carter.
Mr. Eisenberg.
Eisenberg, I apologize. Mr. Eisenberg is present on behalf of Lewis County. I've reviewed the materials that have been submitted and prepared to hear argument. Mr. Thomas?
Your Honor, this is an egregious situation where Lewis County, by its own admission, stated that the answer was late. This is impermissible. There is no reason to excuse it. There's no justification at law, no justification in the court rules, and this is going to be a detriment to my client. He's going to be harmed from this. There are a lot of allegations made in the complaint, claims, defenses that my client didn't have a chance to vet. He didn't have a chance to look at these issues and pursue them through discovery. The Washington State Supreme Court, as I've stated in my filings for this court, stated that discovery is a fundamental right, and this could be a violation of Mr. Hupy's access to the court if Lewis County is allowed to file a late answer at this juncture. They had a chance to respond. We were here at a March 23rd conference scheduling the merits hearing, and Lewis County had a chance to speak up and say either one of two things. One, we don't have an answer filed. We'd like to file an answer and we'd like more time.
I'm sorry, I have to slow down, sir.
Oh, sorry.
One of two things.
One of two things, that they would like to file an answer, or two, that they have a motion to dismiss that they would like to rule on. Either of those would have allowed their answer to come in under the court rules. But they chose to do neither. They stayed silent. Plaintiff's attorney, I objected at that hearing on other grounds. They had the same chance to object and to try to put their objections on the record, but they chose not to. This matter has been going on since December 13th, 2017, and they only filed an answer in the first week of April. That's unacceptable. The Thurston County Superior Court rules prioritize an expeditious hearing on the Public Records Act. This is a violation of the state court rules, the state civil court rules, and Thurston County court rules, and a violation of CR 1, and my client's due process, my client's constitutionally protected due process rights, because this is an ambush upon him. He already filed his opening brief. Lewis County is basically filing an opening brief with their answers and with their facts that they're stated and their defenses. And then Mr. Hupy not only has to defend against their claims, but against all of the new material brought up. That's not fair. That's a violation of the intent and spirit of what a response is supposed to be. This is an ambush, and it needs to be stricken from the record today.
Thank you. Mr. Eisenberg?
Thank you, Your Honor. Lewis County's answer is admittedly 4 days late. The motion to dismiss was timely filed. It was filed within 20 days of service of the lawsuit. It was not heard because the parties engaged in settlement negotiations and asked the court to stay this matter while they did so. It didn't ultimately result in a settlement, and we came back before you for a scheduling conference as this stay order suggested we would. Your Honor at that time indicated a preference for setting the case for a merits hearing. That's Thurston County's typical practice. Because the types of legal motions in my motion to dismiss in here at the merits as well, you can make such arguments at the merits hearing. I figured we could just go ahead to the merits hearing. It didn't strike me as being something special that needed to especially be brought up. It is true that after that hearing, any argument on our motion to dismiss would be required to be filed within 10 days. I can honestly tell you that I did not know that portion of the rule. It's hidden up above in a large set of text. I ended up filing my answer 14 days later instead of 10 days later. So I apologize for being 4 days late. But I note that Mr. Thomas filed his opening brief 3 weeks early, so I did not know that he was going to file his opening brief before I had filed my answer. In fact, he filed his opening brief before my answer was due under that rule. So even if I had time to file it, he would still be facing the concerns that he's raising. I also wish to point out to Your Honor that the arguments that Lewis County made in its answer and in its opening brief in this case, or excuse me, in its response brief in this case, they're very duplicative of arguments made in the motion to dismiss, which has been out there the whole time. And they are largely dependent upon briefing and argument that was articulated in the prior case, which Mr. Thomas worked on behalf of the same client. He got to engage in discovery and do full briefing and argument in that case. And the major thrust of Lewis County's defense in this matter is that this is a refile of that case and the issues are identical, except for the added issue of issue and claim preclusion because it's a refile. And those issues were filed in the motion to dismiss. So really nothing new has come out of anything that Lewis County has done. And it does not strike me as accurate that Mr. Thomas is as unable to have anticipated the defense as he seems to feel to be. I ask Your Honor to deny the motion to dismiss and for sanctions because of that. If Your Honor wishes to alleviate any prejudice Mr. Thomas articulates, there are other remedies than waiver or striking an answer, which he has not sought, because this is more like a motion for default than it is a motion to alleviate that prejudice. So I'm asking Your Honor to deny those motions. Thank you.
Thank you. Mr. Thomas?
Your Honor, Lewis County's arguments that this is a motion for default and that they need to have this answer ring hollow. Let me direct this court to Mr. Eric Eisenberg's declaration filed in this manner, which is on page 3 of Lewis County's response to the motion striking for sanctions. I'm not sure if it's on a different page for this court. Mr. Eisenberg testifies, quote, "I do not think the answer was particularly important to apprise the plaintiff of the nature of Lewis County's defense in this matter." So either it's important or not. Either they need the answer or they don't need the answer. Mr. Eisenberg is stating here that it's the same case, that it's the refiled case of the last time. Well, if it's a refiled case, then they should be able to go ahead with the arguments that they presented in the motion to dismiss. They don't need to challenge facts. They don't need to raise new defenses. So it's either the same case or it's not. And he stated unequivocally in his declaration that he didn't think it was even important to tell us about it, to apprise the plaintiff of the nature of Lewis County's defense in this answer. That states to Lewis County's intent that they didn't care and that this was an ambush. Plaintiff filed a declaration that Mr. Eisenberg told plaintiff that all civil actions in Washington State are an ambush. That's on the record in this case. And then he states here in his own declaration that he does not think this answer was important enough to even apprise plaintiff of the defense in this answer. That's the definition of an ambush and a dilatory tactic. He admitted that it was late, and he's giving contradictory and irreconcilable statements to this court. This court needs to strike the answer.
Thank you. This matter is before the court on Mr. Hupy's motion to strike the answer filed by Lewis County in this matter. This case was filed on December 13, 2017, was served on the defendant on December 29, 2017. The defendant timely filed a motion to dismiss this matter on January 17, 2018, instead of, at that time, filing an answer that was filed prior to 20 days from service. On January 26, 2018, an agreed order staying proceedings was entered. So when we're looking at the timing of this case, I think it is important that no one lose sight of the fact that the parties actually at one point attempted to see if they could resolve the case and agreed to stay it. In that order, it references the stipulation reached between the parties, and in that CR 2A stipulation at paragraph 4, it indicates the facts underlying each case or claim shall also be considered stayed. For all intents and purposes, it shall be as if the claims covered herein are in a timeout until the stay expires or is lifted. That stay, of course, was in place until the scheduling conference on March 23, 2018.
Objection, Your Honor.
You do not make an objection. I am making a ruling. At that scheduling conference, the hearing on the merits was scheduled on May 18, 2018, which is next Friday. The court at that time set the schedule for the briefing in this matter, and on March 30, 2018, Mr. Hupy filed his opening brief. And he did file it about 3 weeks early. I'm not going to, it's nice to have briefing early, frankly, from the court's perspective. And so, although that issue was raised that he filed it early, it's because he's prepared and he was ready to file the brief. On April 4, 2018, Lewis County filed their answer to the complaint. Under the rules, that answer was about 4 days late. Mr. Hupy's argument is somehow that really I should be looking back to the service date of December, or I should be looking back to this period when the case was stayed, or I should be looking back and then in fact do look back to March 23rd, and that somehow this answer was months late is really what Mr. Hupy is saying, and that in fact could not be the case in any fashion, although that's what he argues. But no one could construe the facts that way because of procedurally how this case has gone forward. And I do know that the scheduling conference was scheduled by way of a notice of hearing on March 9, 2018. That was one date I did not indicate. And so Mr. Hupy's claim that Lewis County has acted outrageously and that they are trying to subvert justice and all of those things are not well taken, and they're not under the facts of this case. It is clear to the court that perhaps Mr. Hupy and Lewis County have some sort of history together, and that history perhaps clouds their view of this case. I'm looking at this case and not at some history that might exist between these parties. There is little prejudice to Mr. Hupy as it relates to Lewis County's response, but there are certainly remedies available to Mr. Hupy so that any prejudice that there might be could be alleviated, and that certainly I understand, and that is not how somehow striking the answer. That is not an appropriate remedy, and the court would deny that request and would deny the request for CR 11 sanctions. It would be completely inappropriate, and I agree. The remedy, if someone doesn't respond, is to file for default. The court does regularly sees answers, right or wrong, that are filed days late. Sometimes they're filed months late. That did not happen in this case, and certainly an answer that's filed months and months late, perhaps the court would look at this differently. So if Mr. Hupy does not believe now that because the brief he filed did not address materials that were raised in the answer, the court would certainly grant a short continuance, not a long one. I know these parties want this issue litigated, but I could grant a continuance of this hearing for a period that Mr. Hupy could suggest so that he could file an amended opening brief to address any of the issues that he did not believe that he appropriately addressed because he had not reviewed the answer. That is what is an appropriate remedy, and that is what this court can certainly offer to Mr. Hupy. So Mr. Thomas, recognizing that I have denied your motion today, would you like me to set this hearing over for, I don't know how long it'll take you to file an amended opening brief, but no longer than a month, obviously, I think, so that you could file an amended opening brief if in fact that is what you believe was appropriate to ensure that Mr. Hupy's been able to put all issues appropriately before the court.
Before I answer that, Your Honor, in Jafar versus Webb, which is
I'm not hearing any further argument.
This
if
is
you
an
would
objection,
like,
Your Honor.
if you
Your
would
Honor,
like to,
this court has to hear my objection.
No, I don't have to hear your objection. I ruled, and so my question is, if you would, I would be happy to set it over, and so I'm asking you if you would like the court to set it over. And so if you would like me to set it over, you can tell me about how long you would like me to set it over, and I will do that. So that's what I'm asking you right now.
Your Honor, this court erred in its construction of the facts, and this court is not following.
Mr. Thomas, I am not going, you want to file for reconsideration? File for reconsideration. If you want to seek another remedy, do that. I have a question to you. I'm asking you to answer it. If you don't, I will just continue the hearing for 4 weeks so that you have an opportunity to file an amended brief. But I don't even know if that's what you would like the court to do or whether or not you want to go forward next week and have the hearing. So that is my question to you. Could you please answer that question?
Because a 1-month continuance would not allow Mr. Hupy to seek discovery in this case, Mr. Hupy asked this court for certification to appeal these constitutional questions to the Court of Appeals Division 2.
Mr. Eisenberg?
I think that an interlocutory appeal would be inappropriate in this case. If Mr. Hupy feels that he would win on his claims of prejudice and that Your Honor has erred. The case is scheduled to be all but over next week, potentially, and he could take an appeal after judgment and still have those issues addressed in almost exactly the same amount of time. And of course, if Your Honor were overruled in that regard, he could come back and then any remedy would still afford him his right to do what he wishes. So I think an interlocutory appeal is inappropriate, and I'd ask Your Honor to deny that request.
If he would like to file for an interlocutory appeal, I think that that's fine. So are you asking that I strike then the hearing that's set for next week?
Yes, we would like to file an interlocutory appeal.
All right. So are you asking that I strike the hearing that's set for next week?
Yes, and for this court to certify the question of whether the answer needed to be stricken from the record.
I will do that. And so you can present an order that would accomplish that, and I'll strike the hearing that's set for next week.
Thank you, Your Honor.
Thank you, Your Honor. I have an order denying the motion to strike him for sanctions. Would Your Honor like me to interlineate that you are striking next week's hearing on this order?
Yes, please. Pursuant to Mr. Hupy's request.
You see what I mean?
Okay.
Here's a copy for you. It doesn't have anything I'm bringing up. Do you want me to write it again?
That's
Mr. Thomas, do you intend to present an order at a later date as it relates to the issue with the interlocutory appeal?
Yes, we would like to be specific about what's going to be appealed.
Well, you indicated that it was my denying this motion.
Okay, we would like to have something written for the record so we can,
I agree. I'm just asking when you would like to present that.
in the next 2 weeks. Mr. Hupy's indigent, so I'll have to see when it works for me to get down here.
So the hearing's on Fridays at 9. So which, do you want me to set that for next Friday or the following Friday for presentation?
I'll do it next Friday. I was planning to come down next Friday anyway.
All right, so I will set for presentation the order as it relates to the interlocutory appeal, and so that'll be May 18th at 9 a.m. on the civil motion calendar.